The following program is suitable for general audience of any age.
Tonight, we discuss the emerging legal issues pertaining to innovation within Sri Lanka. Can the currently existing legal frameworks adequately create a conducive environment for development? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty here on Other Derana News Channel, where we bring to you key legal concepts and break it down for the layman. Now today's topic is something that's very curious and we have touched previously in the past, but we haven't quite gotten to the overarching aspects of it, specifically when it comes to the international aspects as well, and that is on innovation, specifically when it comes to intellectual property as well. So to speak about this, we have someone that is not a new face on the program, but has been quite some time since we've been able to welcome him back. We're very glad to have you back in the studio, Professor Sampath Punchihewa, the Dean of the Faculty of Law of the University of Colombo. Professor, thank you so much for coming back to the studio after quite a long wait to help us understand this area. We really appreciate your time. Here's how we're going into this topic specifically. We're going to be getting into the fundamentals, helping us understand and break down some of the key concepts behind the term of innovation, what exactly it means when it comes to the legal sense. Next, we'll be getting into the practicalities, the current world context, and finally, we'll be getting into what we can expect this area of law to develop in the future.
Hello, my name is Shinoli and I'm currently a final year student at Sri Lanka Law College. My question is on the fundamentals. What are the laws related to innovation in Sri Lanka?
All right, well, without any further ado, let's get right into the nitty-gritties of this topic. It is quite a vast area that's not concretely boxed in like we usually do, but it's a very important area, specifically considering Sri Lanka's future development as well. Thank you once again, Professor, for your time. Now, before we get into any of the technical specifics, I think it's important for laymen at home and also law students to understand exactly what is the significance of innovation in a sense, and per se, what the difference is between innovation, invention and discovery. If you could lead us in with that.
Thank you very much for that question. It's a very pertinent question that you posed to me. In answering that question, I would like to state that these three concepts, innovation, invention and discovery, are the most important in the discussion of innovation and patent law. So innovation is a very common, broad term because we generally say, I need innovation, and everybody says that. Innovation means doing something new. It's a business term. Innovation, doing something new. It's a very broad. Invention is very patent specific term. In the patent law, we protect, countries protect inventions. Invention is a solution to a specific problem in the field of technology. Something, finding new object or new process or something new in the field of, as a solution in the field of technology. Discovery, on the other hand, is an act of finding new facts in the nature. For example, now there are certain phenomena. In our society. For example, the earth rotates around the sun. That's a phenomenon. And that is, if somebody finds that, it's a discovery. But if you find a solution to a very compelling disease or new medicine, pharmaceutical, that may be an invention. But if you want to do something new, now we conduct lectures on site, face to face. But you have virtual, conducting lectures via Zoom. That is something, doing something new. That is innovation. So there are these three terms are important to understand the innovation landscape of a country. Innovation landscape. So innovation is a broad term. Invention is a patent or patent specific term. Discovery is something, the act of finding something that exists in the nature.
Exactly. And I think that leads us to the perfect segue for us to actually understand the depth and the significance of what innovation means. Specifically from a legal perspective, Professor, if you could help us understand why innovation is such an essential factor for a country's development.
I think the most important word that in today's global development discourse is the innovation, because the innovation drives the development, technological advancement, and also wealth of the nation. Sri Lanka is no exception to this reality. Why? Because innovation-driven countries are the most advanced, developed, and wealthy economies today. Now, as you know, the United States of America, the European countries, East Asian countries like South Korea, Japan, all these countries have given priority to innovation, and they have been successful in their driving innovation in the country. Therefore, any country in the world should give priority in their policy paradigm to promote innovation.
Exactly. A very important point, as you mentioned, the promotion of innovation is essential. Now, before we get to the legal frameworks that exist, Professor, a question arises. Can a legal system effectively balance restriction and innovation? Because regulation sometimes is the death of invention. If you could help us understand if law can also serve as a catalyst for innovation.
I like the word, your choice of words. Catalyst for law can be a catalyst for innovation. I agree, because if you don't have regulation, if you don't have laws to protect innovation, the investment that has gone into the creation of innovation will not be recouped or regained or recovered by the inventor or innovator. Why I say so? So now, for example, if you are producing a new medicine or drug, you have to invest resources. You have to dedicate your valuable time. You have to engage in laboratory research. And then it is a lot of efforts, R&D, research and development. And when you engage in research and development with lot of expenses, lot of resources, you should be able to capture, you should be able to recoup that investment. And if everybody is taking your investment and fruits of your investment for a free ride, taking your investment and fruits of your investment without paying, then that scenario can lead to discouraging the inventor, innovator or investor who engage in viable activities, economically viable activities. So we need to, I would say in innovation term, in the innovation terminology we call free riding. Somebody taking undue advantage without investing resources, but taking advantage of somebody else's effort. So that we need to stop that. That is where you have to allow inventors to engage in economically viable activities while giving them rights and striking a balance between regulation on one hand and also innovation on the other hand. So if the innovation are free to grab by everyone, nobody will invent, nobody will invest, nobody will engage in economically viable activities. Therefore, we need to reward, we need to provide incentives. That is why law has to come and mediate. Law has to come and intervene and give you rights for your invention. That right, you might have heard about patent rights or intellectual property rights. So intellectual property rights are to give you exclusive benefits, exclusive entitlement for that is to reward your effort.
Yes, that's exactly what I wanted to get further into as well. Professor, as you mentioned, the legal framework area, intellectual property rights and their protection. Apart from that, Professor, if we could go a little bit more in depth in relation to the legal frameworks that exist in Sri Lanka's current landscape that are conducive to innovation and that supports innovation.
Specifically, the law governing intellectual property rights in Sri Lanka is a piece of legislation is known as Intellectual Property Act number 36 of 2003 and amendments made to that act. The principal enactment is the Intellectual Property Act of Sri Lanka, and that has recognized the fruits of intellectual creations. Copyright, patents, trademarks, trade secrets, industrial designs, geographical indications, and other main intellectual property rights are protected, recognized, protected by the Intellectual Property Act. So the legal framework per se as such, I would say the Intellectual Property Act of 2003 is the current law, and the law has been amended several times to embrace the development and also need of the society.
Yes. Before we go into a little bit more in detail relating to this piece of legislation, I think a very important question that arises is, in your legal opinion, Professor, where exactly Sri Lanka stands today when it comes to terms of innovations? If you could just give us an outlook of what it looks like at the current moment.
As my thinking process goes on, I'm not very satisfied. Neither am I happy about the current status of innovation and protection of intellectual property rights in the country. I have good reasons for this considered view. In answering this question, I would invite you and all the inquisitive minds in this country to look at the patent statistics during last 20-30 years. Sri Lanka has not spared well in terms of patent filing and patent registration compared to many other countries in the region. Forget about more advanced developed countries like the European countries, the UK, USA, and even Japan, Australia, China. The countries in the world are engaging in a race to be the first inventors, to bring the first product to the market, and to find solutions. But unfortunately, in last 7, we are nearing the 8 decades since independence, we have not made, I emphasize, significant strides, significant waves in the innovation landscape in Sri Lanka. And the technology, we have not made significant stride in the technological landscape ladder. So that is where we pay the price. And we have faced enormous economic hardships in this country. But our people are extremely talented, genius. However, we have not done our part looking at the pattern statistics. So if you just take China, People's Republic of China, having recorded, registered millions of patents. Japan, the United States, just think about Singapore. Countries in the world, irrespective of their level of technological and economic development, have been at the forefront of at the forefront of innovation, having recorded many patents, having filed many patent applications. But in Sri Lanka, if you just have a glimpse of the patent filed and registered, I would say we have to paint a very worrying picture about our country.
Yes.
But we are not a nation of backwardness, because nation that has proven track records in our past during our country's historical periods, we have been very innovative nation. However, today, I don't know, for whatever the reason, it's a worrying development, and I feel that Sri Lanka should have done better.
Professor, I think that's an area that we can delve into further as well when it comes to maybe the final segment, just to understand what the way forward can be when it comes to the legal context of innovation in Sri Lanka. But before we speak about any of the other specifics relating to the currently existing legislation as well, we do have to take a short commercial break. You're watching Law, Land and Liberty here on Other Derana News Channel. We'll be right back after this, so please stay tuned.
Hello, my name is Anujana and I'm an undergraduate in data science. My question is on practicalities. Are the current laws adequate for the development of intellectual property rights?
Welcome back to Law, Land and Liberty here on Other Derana News Channel. We're in conversation with Professor Sampath Punchihewa, the Dean of the Faculty of Law at the University of Colombo. Professor, thank you once again for the previous segment. We just got done speaking about the very concepts and basis of innovation and specifically how it fares in Sri Lanka at the current moment. Unfortunately, I had to interrupt you and we had to go in for a short break. But much before that, Professor, you mentioned about the key piece of legislation that already exists in Sri Lanka when it comes to being conducive towards innovation. If we could delve a little bit into the already existing pieces of legislation with me here today, Professor, can you help us understand and highlight the areas in which it shows that the existing legislation actually has proper frameworks in order to help protect creators and also to ensure that there is proper access and regulation of technology and specifically when it comes to the knowledge of emerging and developing technologies as well. How does our legislation fare in that context, Professor?
If I take if I consider the intellectual property rights,
yes,
the emerging technologies have been always a challenging point because the current Intellectual Property Act has been was enacted 2003, and since then we have lived with this piece of legislation almost 20 plus years. And then technology has been moving very rapidly. Sometimes we might have not thought about certain things when the act was drafted. Therefore, modern developments will have to be taken into account when the act is interpreted. However, in terms of this question, I think we have copyright segment that has been challenged through technologies, and also we have patent law. Also, patent rights are protected under the Intellectual Property Act, because Sri Lankan law is treating intellectual property in one piece of legislation. This piece of legislation has provided for all areas of intellectual property rights. Unlike in some other countries where you have different pieces of legislation to deal with copyright separately, patent separately, trademark separately, industrial design and other areas like trade secrets separately. But Sri Lankan approach is a codification approach. We have one main principal enactment, one law, one act, and that act has provided solutions. But to be very precise on your question, certain areas at the moment are needing modernization, revising, and also perhaps revisiting of the current parameters, because certain things might not be working perfectly to meet the needs and the challenges of the current technology-driven societies, because we are moving into the fourth industrial revolution.
Exactly, with technology being at the forefront of all of these issues. Now, a question that arises very rightly, as you mentioned, Professor, is emerging technologies, especially now, the elephant in the room is, of course, artificial intelligence. If you could help us understand, Professor, if our currently existing legislature is robust enough to be able to handle the rapid changes when it comes to artificial intelligence in protecting the rights of intellectual property.
That is the, I think, most important segment that I'm touching, I'm addressing in this discourse, this intellectual discourse. As you know, the rapid pace of development in AI has challenged the perceived boundaries of the intellectual property rights. I will take two examples. One is copyright. Today, the copyright is not always protecting the creations of human author. Same is true with regard to inventors, inventorship generated through AI assisted technologies. So these two areas, copyright or artificial intelligence assisted copyright work creations, and also artificial intelligence AI assisted inventorship are not common, not recognized in this IP Act. That is where we need to find solutions, because the IP Act of 2003 does not capture this idea. If you delve deeper into the provision, Section 6 of the IP Act deals with copyright, and it does not capture non-human authorship. It says human authorship. Then when the work is created by non-human, then I have a problem in applying this provision to AI-assisted, AI-created copyright. Same is true with regard to AI-assisted inventorship. So AI system invents something new. Can that AI system be nominated as, designated as the inventor? that problem has been confronted, created controversies in all leading jurisdictions. Dabu's case, if you have heard about it, that AI-assisted invention has created legal battles, legal disputes in the US, in the EPO, European Patent Office, in the UK, as well as Australia and India. So I think if we are to grapple with this issue, controversy, I don't know how the Sri Lankan law would respond, because we have no provisions to recognize AI-assisted inventorship and AI-assisted authorship.
On the context of artificial intelligence, Professor, as you very rightly said, there are certain lapses in our current legislation, which leads me to ask this question relating to whether we need completely new frameworks considering artificial intelligence, or is it sufficient enough that our current legal landscape is just amended for the emerging technologies? What is your opinion on that, Professor?
It's just extension of my response to your previous question. I think doing something new or introducing a new amendment or new act is not necessitated, because if you do that, every time when you get new challenges, new technologies, you have to amend the law, you have to bring in new laws. Of course, what we can do safely is to revise the law to suit the emerging trends and emerging needs. So in that I would say that with regard to the key areas like AI-assisted authorship, AI-assisted inventorship can be dealt with by an amendment to the current law. Now, I would advise, I would emphasize that Sri Lanka can learn many lessons from developed and more advanced jurisdictions, countries, because the previously mentioned Dabu's case has created a significant waves in other countries and disputes. So the other countries also had the same issues, and because Sri Lankan law is by and large complies with the international best practices. Nevertheless, the emerging trends have not been taken into the consideration of the Act. Therefore, the lessons, practices that we can learn from countries in the developed world and also emerging countries like Singapore, South Korea, Japan, and some other countries in the Asian region can be used as the good reference points for us. And the US guidelines, US Patent Office guidelines, European Patent Office guidelines, and Australian Patent Office guidelines can be looked at by Sri Lankan policymakers to revise the current law with regard to AI-assisted creations and AI-assisted inventions. What is clear, there is a bright line rule. What is clear to us is that AI-generated innovations, AI-generated creations are not protected under the IP Act. That is crystal clear. Nevertheless, there is a flexibility, there is a leeway when you deal with AI-assisted creations and innovations. So I would say the current IP Act should be amended, revised in order taking on board the lessons or the best practices from the the more sophisticated, more advanced jurisdictions in revising the law.
Yes, and as you very importantly pointed out previously as well, when it comes to the ownership, the authorship and responsibility, that is an area that is a little bit controversial as of the current moment due to the emergence of technologies like artificial intelligence. I want to get to specifics and understanding the consensus in that aspect as well. But before we go into any of those detailed areas, let's take a short commercial break. You're watching Law, Land and Liberty here on Other Derana News Channel. We'll be right back with the final segment, so please do stay tuned.
Hello, my name is Nithini and I'm a product designer. My question is, on the future, what can we expect as developments in this area of the law?
Welcome back to Law, Land and Liberty here on Other Derana News Channel. We're in our final segment in conversation with Professor Sampath Punchihewa, the Dean of the Faculty of Law at the University of Colombo. And we were just getting done speaking about the nuances of innovation in terms of a landscape that is increasingly infiltrated with artificial intelligence and how exactly our existing legislation is going to intend to compete with these kinds of issues. Thank you very much, Professor, for the previous two segments. Unfortunately, time is flying pretty fast and this is our final segment. So before we left off on the break, there's a very important area that you pointed out, which is the ownership and the authoring of new ideas and innovations that are intended to be protected under legislation such as the Intellectual Property Act of 2003. If you could help us get a little bit more clarity into relations of how exactly the currently existing legal framework approaches ownership, authorship and responsibility, especially considering how innovation in itself is also evolving now due to the emergence of technologies like artificial intelligence. This is probably going to be an extrapolation of your previous response, but I think some clarity would be appreciated.
Yes. So I would straight away answer that question. With regard to ownership rights of the artificial AI assisted creations, when you have the author, human author, then the rights can be assigned to the human author. Same is true with regard to AI assisted inventorship. So AI assisted inventorship brings in new technological device. So that ownership also should be assigned to the human inventor, though he was assisted significantly by AI systems. So that conclusion can be reached. That is the moment the law recognizes AI assisted inventorship, the rest of the provisions in the IP Act can deal with ownership matter,
Right.
ownership and commercialization and other related matters.
So a question of curiosity that arises in this area specifically, I believe this is not directly related to our topic, but it is important to get a bit of an understanding. If autonomous artificial intelligence systems pose harm or a risk or threat to the human populations, how exactly is liability even considered in that kind of context, especially in the existing laws? If we can just have a little bit of basic understanding on that.
It's quite of a challenging question, not only to me, but also to any experienced lawyer,
Yes.
or even a bench of judges, because we are yet to grapple or tackle this issue. Now, suppose some time ago, I think a couple of weeks ago, I saw in China, the autonomous vehicles, cars, stopped in the middle of the highway. And then that can cause collision, that can cause enormous accidents. And then also when you have autonomous vehicles, AI-driven autonomous vehicles on your road and streets, that can cause accidents, that can cause damages to human and property. Because all these are programmed, and then when you have some accident, everything will be, there can be traffic jams, there can be also damage to human and property. I think then we have to go back to the legal principles. If anyone causing damages to human or person or property, then you have to take the responsibility. And then this is here, if it is unintentional, then you have to, maybe by negligence or by any other cause, maybe system has been hacked, and then it causes certain vehicles to collide. Then that may be intentional. Somebody has intervened. In these two scenarios, if it is unintentional or if it is intentional, then we have to deal with the normal legal principles that applies to the causing damages to persons and property. I think in that we must take it as a test case and try how legal principles can be established. Legal principles on liability can be applied to new scenario. Okay?
Yes.
It's something like that. All wine in new bottle scenario.
Yes.
Okay.
Exactly. A very apt way to put it as well. Now, moving forward, we are unfortunately running out of time. So before, in case we have any sort of duration issues, I want to ask you, Professor, in your legal opinion, with the trends that you have seen while studying this area specifically, what do you think we can expect as changes or amendments or reforms, any sort of evolutions when it comes to the already existing legal framework in relation to intellectual property and innovation in general?
We discuss intellectual property responses so far. Moving away from that, we can, there's a civil liability, law of delict, and law of tort in the UK, and our legal system is blessed with both the Roman Dutch law principles of liability and also English law principle to a certain extent. We can use them flexibly enough. Nevertheless, I should draw your attention to the recent European AI Act. The European Union championed in introducing a new AI Act, and that has captured employment-related matters, contract-related matters, and many more. So I think in bringing the legal system on par with international developments, we can look at the European, we call EU AI Act. And perhaps as a country, we should consider how best we can adapt such a legal environment for future development of technology. Because I think AI has changed the way we work, the change we do day-to-day activities, and also the way that we create, we invent. And we should also find solution to grapple with issues caused by or faced by the modern technologies.
Exactly. Now, a very important area that you touched on just in that previous response is the fact that we can learn from other nations, and also that leads me to get more clarity relating to how we should handle as a country with its own legal framework, how we should be interacting with the rest of the world and their legal frameworks when it comes to innovation. With technology increasingly transcending national borders, how significant, Professor, do you believe it is for international cooperation when it comes to the regulation of innovation?
Sri Lanka, by far, is in line with the international obligations in terms of intellectual property law. But we are not perfect. We should adopt modern developments, in particular internet-related, AI-related areas. And the law is still developing in many countries. Nevertheless, the advancement in legal responses in the European region, the UK, the US, and also in other emerging economies, emerging countries in the East Asia, Asia and East Asia, like Singapore, can be looked at as reference points for us. Nevertheless, I would say, word of caution, we should not, I emphasize, we should not take certain laws from other countries in the manner that is a transplant. In my words, I would say blind transplantation of foreign systems, foreign provisions, laws, because that would not work in the body of Sri Lankan law. Because there are, when you learn from other countries, there are different approaches. One may be formalistic approach. The other may be contextualist approach. What people tend to do is transplant. Transplant, when it is blind transplant, taking the international experience in total without contextualizing that with the socio-economic and legal background of the country, you try to bring in the same. It does not simply work. It is bound to be a failure. I think that is where we need a bit of serious thinking and also critical thinking. Otherwise, like some other statutes that we have brought in, implanted in Sri Lanka by way of blind legislative transplant, has not been successful. I think that is where my precaution. We need to also alert lawmakers, policymakers to consider the appropriateness of particular law that we learn from other countries. Nevertheless, we have common law heritage in this country. Common law heritage has trained our minds in such a way. So our members of the legal fraternity are more accustomed to look at the English examples, British examples. So even when we have certain things to modernize our laws, certain areas to modernize, then I think perhaps safely and also rightly we can look at the experience emanating from the UK, because we have more similarities than not.
Yes, perfect words for us to have to unfortunately cut this discussion short. Thank you so much for taking the time to help us understand this very vast topic area and try and trickle it down to the layman and also law students to better understand this area. Professor Sampath Punchihewa, the Dean of the Faculty of Law at the University of Colombo, we really appreciate your time. Thank you so much.
Thank you for having me.
All right, well, we leave you tonight with the words of John Locke. The end of law is not to abolish or restrain, but to preserve and enlarge freedom. For in all the states of created beings capable of law, where there is no law, there is no freedom. Thank you very much once again for watching us here tonight on Law, Land and Liberty. Have a great night.